Good afternoon. Today is our episode 15, I believe. So today we're going to cover the requirement for the vaccination for applicants for adjustment of status in the United States. Just last week, the FDA has granted full approval for COVID-19 vaccinations, such as for Pfizer and Moderna, and in next couple of weeks, Johnson & Johnson as well. Now, the Center for Disease Control and Prevention has already advised the civil surgeons, the doctors responsible for preparing and submitting the requisite medical examination for people to comply for adjustment of status purposes. Meaning, if you're applying for a green card, you're supposed to comply and have yourselves vaccinated for certain immunizations that have already been required as mandatory for people who intend to migrate to the United States. Now, with COVID-19 vaccinations, the CDC has already issued a guidance that for those applicants and applications starting October 1 of this year, primarily because the fiscal year for USCIS normally starts on October 1, they're required now to show proof that they have been fully vaccinated. It's not just 1 or 2 shots, but full vaccination is being required. There are blanket exceptions to this, such as moral or religious grounds or non-availability of the vaccine. But the CDC has been quite clear that even though you have moral or religious considerations or exemptions that you intend to file, at the end of the day, it's the USCIS that will decide such exemption. And also immunity from COVID, for example, based on blood tests. Some people had COVID before, based on blood tests, may have immunity from COVID-19, but insofar as CDC is concerned, this does not suffice in meeting the requirement that a vaccination should be had. You could be immune from COVID because of the presence of or results of the COVID blood test, but still you're required to undergo and complete the whole vaccination process. Otherwise, if you refuse to do so, this could be a basis for you to be considered as inadmissible to the United States, and therefore what that means in layman's terms is that your application for adjustment, your application to migrate to the United States could be denied as well. Now, there's a practical potential problem to this. I'm referring to those people who intend to migrate from other countries, considering that there might be vaccines that are have to be identified, whether, for example, aside from Pfizer or Moderna or probably even Johnson & Johnson, any other vaccines would suffice for the purpose of meeting these particular requirements. And also there's a problem also as to the validation. These are problems that the immigration has to deal with, the Department of State have to deal with also in terms of validation, but I could just foresee the potential problems that the whole process may entail. I'll revisit this once the details are thrashed out by either the Department of State or the USCIS. Now, the second subject for the day is the requirement or the flexibility extended to applicants in responding to notices from immigration insofar as requests for additional evidence, notice of intent to deny, notice of intent to rescind. When you file an application, sometimes immigration would request you to comply with certain documentation that they may ask from you, and there's a deadline to this. Cognizant, recognizing that the COVID realities that we're all in, USCIS, the service, has extended the time period within which to comply with this, and that this one refers to the applications that have been filed on or before March 1, 2020 up to September 31, I believe, of this year. So if you have a specific deadline set by the RFE or the notice from immigration, you're given 60 days from the date of such deadline within which to comply before an actual decision could be rendered in your application. Now, insofar as the motions to reopen or appeal or request for a hearing for naturalization purposes, the same amount of time has also been given for the applicants to comply with such reglementary or period within which to appeal. So hopefully this will do for now. So again, this goes to the requirement of the COVID-19 vaccination to complete the whole series, and also in how to comply within the time period given by immigration. Normally you're given a specific time, but you're given extension of 60 days based on these new regulations. So if you have any further questions, please consult a lawyer, just to be specific, just to be exact and accurate with as far as these regulations are concerned, and so far as how they may be applicable to your particular case. Thank you and stay safe.